High quality.
Thank you, Mr. Chair. Thank you for the opportunity to address this revision tracked supplementary order paper number 349 released by the Minister of Justice, the Honourable Judith Collins. And to call the revision tracked supplementary order paper substantial would be an understatement. It amends almost every page of the bill as it was reported from the Justice and Electoral Select Committee. And so that version, the 90/2 version of the bill, contained substantial amendments. And the supplementary order paper 349 seems to be last-minute stuff. It has only been released today, Tuesday the 3rd of September, the day we are debating the detail of the bill. And so if we look at the changes just to Part 1 of the bill, which we are now debating, how much has been changed by SOP 349? Part 1 of the Family Court Proceedings Reform Bill contains many changes, sir. Some very important changes to the laws of New Zealand affecting our most vulnerable citizens. Mr. Chair, fully 80% of this Part 1 we are currently debating has been changed at the last minute by the Minister in charge. And sir, today I rang some Bay of Plenty Family Court lawyers who have previously expressed dismay at this bill. And I couldn't get hold of them, sir. One was travelling from Rotorua. Another was in court doing what lawyers do. And that's how life should be. We should be working, doing what we're supposed to be doing. And bills that come through Parliament we should be doing what we should be doing, which is putting these bills under full scrutiny, sir. And I ask, where is the opportunity for full scrutiny of this bill? Where is the opportunity for those people, the experts in this field, to fully engage with due process? So this is important because this bill has the potential to affect any child in New Zealand. And so I'd like to now turn to page 26 of SOP 349, where today we have in clause 9, sir, the surprise appearance of new section 46GA being parachuted into the Care of Children Act. And this restricts the counselling available under new section 46E of the Act. Now, that new section 46E of the Act was contained in the bill as introduced back in November last year. And sir, it was substantially the same in the Select Committee report a few months ago in June. There were a few minor changes in the wording. The intent of new section 46E was and is to improve the relationship between the parties, that is the parents, and to encourage compliance with an order or direction of the court. And that sounds like something positive for the children caught up in all this. But, Mr. Chair, now the availability of counselling is to be throttled by new section 46GA, and it says, and I quote, the maximum number of sessions to be carried out must be determined by regulations, or if no such regulations are made, by the registrar of the court. So on the face of it, sir, this is more cost-cutting by the government, and it is more cost-cutting at the expense of the welfare of New Zealand's vulnerable children. I turn now to new section 49AB contained in clause 12 on page 30 of the SOP 349. And this is another whole new section to be inserted into the Care of Children Bill, which again has only made its appearance today. Now, interim parenting order may become final order on specified date. It appears to be quite technical and detailed in providing that, and I quote, a family court judge may, when making an interim parenting order, direct that it has become a final parenting order on a specified date. And there are subsections 2 and 3, sir, which appear not to be contentious. But as parliamentarians have learnt to their cost over the years, the devil is in the detail. And I would ask, why is this change appearing at the last possible minute? Why is it that the experts in the field, the people outside this House, have no chance to scrutinise the new detail of this law? And I would like to hear from members opposite, is there a member of the National Party's Caucus Committee on Vulnerable Children who will say if they have even seen this new section, let alone had it explained to them, or been given the chance to ask any questions about the wording, about the detail, and why there should be new law around whether and when an interim parenting order can become a final parenting order. And Mr Chair, it was interesting listening to the Honourable Alfred Naro, Mr Chair. It was interesting listening to the Honourable Alfred Naro speaking about exiting people out of the family court system as soon as possible. And, sir, this bill will certainly do that. Because this bill will greatly affect the vulnerable people in our society. The parents and those at the centre of all of our concerns, of course, the children. Parents and children will struggle with what it now means to their future as individuals and as a family. And, sir, I cannot emphasise enough the intense waves of anxiety and huge costs emotionally and financially already experienced during these times. This bill will exasperate the very people it is supposed to support with additional legal costs and free counselling removed, adding to the living hell that those parents will already be going through. And, sir, these difficult times should not be undermined, and these parents should not be made to struggle further with legal ramifications, and that is agreeing to things in a process that they don't fully understand or can fully have time to process in their heads, and the costs. And, sir, whilst most New Zealanders love the idea of the family disputes resolution concept and principle, it will actually be met with unfair battles. The expectation that parents will be fairly matched during this process, even with the assistance of one facilitator, is totally unrealistic. As we know in these family battles, sir, one person holds the court strings, one person is dominant, one person will be able to afford a very expensive lawyer in the background giving them advice. And, sir, each parent will have their own view about what is best for the child. And let's not forget that they wouldn't even be there in the first case if this was not the case. Sir, throughout the committee stages, it's been recognised that the focus of this bill is to cut the cost of legal aid, as it has become unaffordable for the government. In fact, the costs have skyrocketed, yet the number of cases have not. I suggest we look at how this can be. What are the real issues for the cost increase? Why are we prepared to cut the services being offered before we really understand where the blow is coming from? But more importantly, making the vulnerable people in our society go without legal representation or an understanding of what they are entering into cannot be right. Sir, we need to listen to family court lawyers all over New Zealand who are saying that this bill is absolutely frightening, particularly as it could leave the vulnerable parties, children, without legal protection. Thank you, sir.
Paul Foster Bell.